So that's the main website. When you use it, like the first thing that's going to pop up is the gala. So that's the main website. If you want to actually learn more about the nonprofit itself too, you can find that there. And if you do buy tickets, if and when you do buy tickets, also there are really good group rates. So individual tickets are only $25 each, but there are different group rates. So like if you buy a pack of 4, it's $70. So then you can use the promo code and get 25% off that. And then there's a pack of 8 that's $125. So grab your friends and buy together, then you can save more money. And I'll put the code in the chat too. I'm done. Thank you, Professor Keel, for letting me do that.
Hey, everybody. How are y'all doing? Happy Friday. Oh. So was it believable that I was really there?
I was talking to you, so
Yeah.
That was awkward.
That's pretty good, right? So Ben is trying to figure out how he can be in class without actually being in class. And he has come up with the screenshot virtual background of himself, which I have attempted to recreate here. So I think it's really effective. I think it's a really good ploy. So I'm not encouraging you guys to use this, but if you need to, you know, just do it. Yeah, I was really impressed with him. So here's my action. You know, so here I actually am. So who is Ben? He is a genius. Ben is my son. So yeah, I guess I presume that if everybody in here has had me before, but you haven't all. So yeah, Sadie is the daughter, Ben is the son, Toby is the dog, Pippa is the new dog, Ginger and Hazel are the guinea pigs. They're in here. Toby's in here actually today too, so we got a Friday afternoon with Toby, so maybe we'll pull him out later in the class. So it's Friday, long weekend ahead. I know, you know, there I see another dog. Is that a dog or a cat, Megan?
That is just one dog.
One dog, got it. So even though it's a long weekend of a different maybe than a typical Labor Day, it is still a long weekend, and so hopefully Friday will feel good. Feels good for me, at least up here right now. Okay, so when do we have class? Tuesday. On Tuesday, we spent really the entire class with this discussion about strategy, and I think that was useful to kind of take a step out of the sort of grind of the cases of the litigation that we are going to study, and kind of back away so that we can have a sense of all of the different options that were on the table and really were being pursued simultaneously with litigation. So even though maybe you think of the civil rights movement as being sort of beginning with something like the Montgomery bus boycott in 1955, and I would imagine that you would incorporate the Brown case in 1954 into that story, it's a much longer story than that. And so even in the 1930s and well before the 1930s, so many of these strategies are being employed. And we remember the civil rights movement and the Brown case as well, and the Montgomery bus boycott as well, because they were successful, right? We don't look back on the strategies that did not work. We only look at the strategies that sort of did affect history or did affect social change. But hopefully on Tuesday, we kind of got a sense of what strategies were available and were all attempted, rather than just focusing in on the one that, or the ones that ended up more successful. The reason, again, I think I said this on Tuesday, but I'll repeat it here. The reason for that, the need to be able to think that way is because right now, or whatever issue you want to pursue as a strategy for social change, whatever that is, you don't know what the strategy that is going to succeed is. It might be litigation. It might be direct action or boycott. It might be sort of using the media in order to build a political consensus. It might be building or lobbying a legislature to get a law changed. It could be any of those things. And so you need to be able to think creatively and really pursue all of those things simultaneously in order to pursue social change successfully, because you don't know which strategy is going to work best. Our focus here is, obviously lawyer centric, although the legal skills and legal analysis, I think, can be helpful in really any of those strategies. But ours, as a lawyer-specific strategy, we are going to focus in, at least in the initial part, on litigation. We'll talk a lot more about legislation during the second half of the course, which we will incorporate. And so I want to just sort of start this discussion with some thoughts about pursuing litigation and the way litigation fits into social change more broadly. And it connects a little bit to some of the things that we've been talking about already, which are the sort of disconnect in the Plessy opinions about the power of law and the way that the law can or cannot affect social change. So if I was asking just sort of for people to provide some examples of things that are good, things that are pros about using litigation to pursue social change, what are some things that people would come up with? So what are some pros to litigation-based social change? Especially thinking in comparison to some of the others. Rebecca.
Ooh, Rebecca. Okay.
Sorry, Chris. It would bind the whole jurisdiction. If you get a ruling in your favor, it binds the whole jurisdiction to have to follow that precedent.
Good. So it can be expansive. It can it just changes things quickly. Chelsea?
So I was going to say it could, if there's like a social movement in one direction, it can be done sometimes faster than maybe legislation can be done. So you might be able to get those rulings in the favor of whatever side you're on faster than if you were to go through, your representative and your senator and things like that.
Good. And then connecting that to Rebecca's point, and it binds everybody, right? Your whole jurisdiction, obviously just your jurisdiction, but your whole jurisdiction. Renee?
It's got the power of enforcement behind it. So
okay.
You can act.
So what do you mean? What do you mean?
Well, if you are successful in getting something litigated and it becomes precedent, which would make it law at that point, then you would be able to have that enforced, whatever it was that you brought forward that you wanted change. So the change itself could be enforced because at that point it would be considered law.
Enforced by whom?
Hopefully by your police department or whoever it is doing your enforcing. I mean, depending on what it is that you had. By the school system, maybe if it was, if it was applicable to the school system, it would be the school system enforcing it. But I mean, by whom would enforce it would depend on what it was that it was, I would think.
But I think the big picture, and it's consistent with everything you're saying, is the authority, right? The government would be the would have the enforcement power on your side if you get a litigation victory.
Right.
In a way that in the moments before you get that victory, the authorities are enforcing in the opposite direction. So if you think about segregation, the authorities are enforcing segregation through, after Plessy. And so what you're looking for is a switch in the side of the government, of the state, of the school, whatever the authority is.
Right.
Okay, Caitlin, you got another pro for us?
Yeah, you could go back and it's a little bit more instructive than a piece of legislation as well, because you could potentially go back and read briefs from both sides, and as well as an opinion, where you might not get that with legislation unless you went and comprehensively looked at the testimony at the hearings or whatever was going on there.
Yeah, in a weird kind of way, even though litigation is limited to the controversy before it, right? It's not, just sort of a broad inquiry into what would be the best policy here. It's limited to a specific question that would be litigated. So even though that's the case, in a weird kind of way, litigation has a way of developing a more thorough record than legislative policy does. And this is because legislative policy doesn't have to be justified, right? If I just have a feeling about something and I can convince enough of my legislators that that's what we ought to do, then, and I get enough votes, then that's that. As opposed to in litigation where everything has to be proven and established. And, you guys might be a little cynical about that and say, well, the judge does what the judge wants to do. And I'm sure that's the case sometimes. But the structure of litigation requires proof. And since it requires proof, there should be a fairly well-developed record that would provide, extra evidence to support whatever it is you're pursuing. Chris, I didn't, just because you didn't raise your hand doesn't mean you don't get to talk. But so did you want to add something? No? Okay. Heather?
Just building off of Caitlin's, I was just going to say that litigation allows people who don't necessarily agree with one side or the other to see things in less emotional light, to see things in a more rational, and like what Caitlin said, linear structure that you could see where people are coming from. It's not just, I feel this way because I feel this way. It's, it could have this effect. The law previously said this, etc.
And there's a neutral arbiter, right? Not only are the parties maybe, the parties are adversarial, but there's a neutral arbiter in here, as opposed to in the context of legislation or, an economic boycott. The issues are not public, they're economic issues. In the area of legislation, the legislators are not, they're not neutral. Like, they're not supposed to be neutral. That's not what it is to be a legislator. Sarah, what do you want to throw in here?
Yeah. Also, the interplay with legislation, it can, as you just said, they don't have to be neutral. They can help bolster support for legislation. And even you can see cases that wouldn't bind your jurisdiction, but you can use that to support your cause for passing legislation.
And it's absolutely the case that legislation affects litigation and litigation can affect legislation. What does it take to get in the door with litigation?
You have to actually have an injury.
So you have to have an injury, but do you have to have a lobbyist?
No.
Do you have to have a lot of people that agree with you?
No, but you have to have money.
You might have to have money, right? Yeah, I mean, so let's be real. One of the things that is interesting about the Brown story, and that, it's just part of the facts. The litigation effort that culminates in Brown and then moves on past Brown versus Board of Education sort of began in the late 20s and early 30s with a huge grant from a foundation to the NAACP to develop a strategy for confronting segregation. And so, yes, it is absolutely the case that the lawyers within the NAACP came up with that strategy, but they were able to come up with that strategy because they were able to hire someone to come up with a litigation strategy person, Charles Hamilton Houston, and Charles Hamilton Houston was able to hire lawyers like Thurgood Marshall to go in and come up with this. And so it's absolutely the case that in reality, you're going to probably need some money, but at least structurally, all you need is a plaintiff, right? A plaintiff and a lawyer in a way that with legislation, you probably need, a movement. And a movement is more powerful probably than one person, but one person can win in a litigation in a way that one person is never going to win in legislation. Heather, is your hand up from before, or did you have something else?
Sorry.
Okay. So what are some of the cons? What are some of the cons of litigation, right? So it's not all good stuff. Yeah, Chelsea?
I mean, so I think mine is the reverse can be true too. And I think it was in Obergefell, right, where the dissent talked about how I think it was, I could be wrong, where they kind of usurp the national process, where some activists got their stuff pushed through when the country was already on that path, and we should have just let the voting powers and things like that move it that way. So you might have a case where one group or one entity now has what they think is the right thing up as law, and not everybody might agree with it.
Okay, and so let's use the Obergefell case. And for those of you who aren't familiar with what Chelsea's speaking about, she's talking about the case that sort of prohibited states from prohibiting gay marriage, same-sex marriage. And one of the dissents in that case is talking about how, the natural process by which same-sex marriage was becoming accepted in society was short-circuited. And so in some states, it was same-sex marriage was legal. In other states, it was prohibited, but there was this constant movement, and that the short-circuiting of that process, Chelsea, the dissent was arguing, actually undermined the movement. How would that be?
So the way that, I mean, if I'm remembering correctly, but basically it was that everybody was already on that path, and it might have taken a little bit, but if you have everybody behind it, it has more power, and you won't have kind of these splinter cells that are going to constantly now rebuke it and will never accept it because it's being forced on them, as opposed to them willingly electing somebody to push it through.
Right. So it's a legitimacy issue, right? So if you have a court decision that is against the wishes of the Democratic majority, then yes, you might have the authorities on your side, as Renee was saying, but you don't have the people on your side, and that can actually stoke resistance, and that might be problematic to the broader movement. Okay. Sierra?
I was just thinking about it in the way of lack of representation or lack of access to representation as a con of litigation, because sometimes parties that really need to be a party can't have access to that. And so that creates kind of an issue where there's going to be an unequal divide on who gets represented. I always think about school boards obviously probably have a lot more power and ability to get representation over children or families who are negatively impacted.
And the school board is a repeat player in these litigations in a way that families probably aren't. But it's a great point. They may develop a record in litigation, but not everybody who is affected is present as a party. And yeah, there might be amicus briefs if you get up to a certain level of litigation, but there's a lot of interested parties who are absent. And then there's a lot of interested parties who may be present, but aren't as sophisticated within the litigation realm. And so, Sierra, how might that skew litigation outcomes?
Sorry, I wouldn't unmute myself. It would skew a lot of outcomes because if you have more sophisticated parties who are actually able to be there and probably have representation and have attorneys, it's definitely going to go one way versus the other. I was just thinking, I guess, in my sense, is almost like low income families who need help, who might like try to represent themselves pro se and like a complaint against a school. And obviously they're not going to have the access to just like the technology or the information to like know enough about the issue to go and represent themselves. Or if they are able to get representation, they might have to go through some sort of legal aid, which also is an issue because we know a lot of legal aids are overflowing with issues and can't just super sit down and work on one particular issue.
Good. Okay, Rebecca, a con for litigation. I'm hoping you'll give the exact opposite of what you gave for the pro.
Oh, actually, yes, I was going to say that. If you lose, then there's law that is the opposite of what you want. And also litigation can take years. And if it's something that's really important that's negatively affecting your child has to stay in that bad situation for potentially years.
Good. If you win, it's fantastic. But if you lose, it is disastrous because now you not only have lost on the question, you have also set precedent that is against you for the next time that you want to bring a similar case. Reggie, got a con for us?
Yeah, I was just gonna say, like, it could be also a little bit more difficult to kind of come up with like legal arguments for your position. Like, it's a lot easier to kind of come up with like social arguments and kind of get people to rally behind it, but then it's kind of harder to take existing law and then kind of like use it as to like craft like a legal argument to pursue your issue.
Great. So let's compare it, Reggie, to legislation. What do you need to get a bill passed in terms of a sort of a theory? What do you need?
Just to kind of like persuade like enough people to kind of like behind your point.
Just need numbers. Like the legislature doesn't have to have any justification for what they do. I mean, obviously, we know that if they violate individual rights, then it can be struck down. If they violate the First Amendment, if it, there's all sorts of ways in which legislation might get struck down, but they don't have to, just like we're saying in the opposite situation, they don't have to justify what they're doing. With litigation, not only do you have to prove what you want, you actually have to prove that there has been an injury, right? So I forget who it was just a moment ago, we talked about what it is that you have to have in order to start a lawsuit. Well, you have to have an injury. And sometimes it's hard to connect a social policy or a public policy that you don't like into an actual legal injury, okay? And so let's just use the two examples we've encountered, like in the Roberts case and in the Gang Lum case, if in fact it's an equal provided, or it's an equal education that's being provided, what's the injury? What's the injury that is being suffered if it is in fact equal, which, we have to assume that it is in fact equal for this conversation for the moment. If it is in fact equal, where is the injury in segregation? Yeah, nobody wants to answer. Or Rachel, maybe you want to sort of to wade in, but that's a really hard question. You're muted.
I didn't know if it was a hypothetical or not, but you made it a hypothetical, so I'm lowering my hand.
Okay. Yeah, I mean, we're going to see how they prove it, right? How they prove that it's either not equal, or that even if it is equal, it's problematic. That's sort of where we're going. But that's really hard to come up with an injury. And what happens as the strategy starts developing is the cases keep getting dismissed, right? Oh, it's equal. Like Gang Lum, it's equal. There's no injury. Therefore, let's move forward. Okay. So we've talked about pros and cons. I think that was a really solid list that we've developed. And you just have to keep that in mind before you embark on a litigation, but also as you pursue a litigation. You know, what are the ways in which this is helpful, and what are the ways in which this might actually undermine the broader effort? Because litigation is rarely an effort in and of itself. It is part of usually a broader effort to, and by the way, litigation in a narrow individual sense. So like Sierra was speaking about, like an individual student who might, let's say it's a student with disabilities who might feel like the school is not providing them with the appropriate resources to succeed or to receive an appropriate education. Okay, so that's not really the kind of litigation I'm talking about, right? So I'm talking about like bigger use of litigation to address a broader either social problem or broader government policy. So that might be, I think that affirmative action is discrimination against white people, and so I'm going to bring in a case to challenge affirmative action. Or I might think that the standards by which individuals with disabilities get their school services provided, I might think that that standard is structurally wrong, and therefore I'm going to bring this case, not just because I think it's being applied badly to me, but because I want to actually change the way in which this is done. So, you know, when I'm saying litigation clearly can matter to individuals. Every case matters deeply to the individuals involved. And sometimes those cases grow into social change type litigation. But, you know, I would encourage you to kind of keep those things separate, right? Strategic social change litigation on one hand, and individual rights violations that need remedies or we want to vindicate the rights on the other hand. I see 3 of you guys have hands up, but I've heard from all of you, and I'm not sure if those are leftover hands or not.
I have a question.
Yeah.
So maybe this was a question for Tuesday, but since we're talking about using litigation as a tool, I thought I'd ask now. So when you say that, I assume you mean that there are more tools you have to use other than litigation. Would litigation be something that you want to secure at the forefront? So like Brown versus Board, secure that and then do the rest of the tools? Because I
would say it depends on the circumstances, right? So maybe let's just stick for a moment with the same-sex marriage social change, right, that occurred. It was clearly important, you know, when we had our list from the other day. Let me see if I can pull it up. Hold on. We had our list from the other day. We had we were talking about cross-racial connections and hearts and minds. I think it was clearly important for a movement towards same-sex marriage that there were allyship or friendship or relationship understanding between the LGBTQ community and the non-LGBTQ community, that this was important, right? And so I don't know that litigation can work on its own. And so I think that I think that maybe sometimes you have to be so far ahead with, you know, of things that litigation should be the front edge of something. But I think that that's probably pretty rare. I think it was rare. I don't think it was the case in Brown. I think that the desegregation of the military, for example, was an important step in moving towards Brown. So it's always a both and, or an yes, 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 we do all of those things. I actually would say that it's probably rare that litigation should be the front end of something, if that makes sense. Others have thoughts on that? You know, litigation as the front end versus litigation as a supportive element of a broader campaign? Yeah, Caitlin. I'm also, even before you speak, Caitlin, you know, I'm thinking of like Sarah's public service announcement at the beginning of class. You know, there's litigation involved in movement to reduce human trafficking, but there's also a huge public relations effort that and sort of informational effort that goes on in that sphere. Caitlin, did you want to add something in?
The conversation we're having makes me think of kind of the concept of a perfect plaintiff. And if you're trying to litigate like a social movement on the front end, then you do kind of find yourself risking maybe somehow giving less respect to the judicial process, because if you're just looking for a perfect plaintiff who matches whatever issue that you're trying to solve, so we're saying, you know, we're looking for someone who's been wronged in some way due solely to the color of their skin, then you are going to be looking for a plaintiff who fits into that mold, and then the judicial process and legislation just becomes something that is maybe less respected.
Okay. Because we're stuck with the plaintiffs that we have, and no plaintiff is actually perfect. Is that am I capturing that?
Yeah.
Okay. Yeah. So, you know, so I guess I'll leave it at litigation is usually an appropriate part of something, but rarely can be successful without other things. And so on some level, that's an acknowledgement that, you know, the Plessy majority is correct, right? If the races be unequal socially, the Constitution cannot on its own make them equal. So I've thrown in the on its own make them equal. I think that that's probably accurate, that the law or litigation as a single factor cannot change things. But I also tend, you know, personally to believe that the law has a role to play, right? That if it's, especially where it's not neutral. Okay, let's talk about Mendez, and then we'll turn to Sweat and McLaurin. And really, I don't want to spend too much time on Mendez. It's a really important case for a couple of different reasons, but it kind of outside of the narrative that we're tracing here. It's just important to remember that the narrative that we're tracing towards Brown includes lots of other branches that are happening sort of in parallel with the Brown effort. And so what we had in Mendez is segregation not by race in terms of black-white, but segregation based on essentially Mexican heritage. It may have been more broader to Hispanic or Latino heritage, but it's very specific to Mexican heritage. And these are the individuals involved. You know, y'all know I like to sort of lift up the actual human beings that were involved in these cases. I believe Sylvia Mendez is still alive and, you know, still kind of active in promoting this particular story. But if I'm thinking about how the Mendez litigation goes forward, the argument that wins, what is the argument that ultimately wins? Is it that segregation is immoral or that the facilities are unequal? Did anybody pick up what is the theory that wins the day in the Mendez case? Who got that? Who's figured that out? And then I do actually want to spend a little more time on the concurrence in Mendez. What's the theory that wins in Mendez? Yeah, Jake.
I remember, wasn't it just that it wasn't legislation passed, that it was like an administrative act? Or am I thinking of a different case?
No, you're thinking of the right case.
Yeah,
So,
yeah. So it's kind of like maybe if the state legislature had passed this, it would be okay. But since the school administration did it, it didn't have, you know, the will of the people behind it.
yeah, it's an authority case, right? So as opposed to in Boston or in Mississippi, in Robertson and Ganglum, where there was state legislation that enabled the segregation to happen, the court here says there's just no authority for these school districts to be doing this. In fact, to the extent that there is any state legislation on this subject, it suggests that you can't do this. And so, you know, I'm looking in the sort of last paragraph of the majority of the main opinion, you know, conceding for the argument that California could legally enact a law authorizing segregation as practice, the fact stands out unchallengeable that California has not done so. So they could have segregated based on Mexican heritage, but they never did. And since they didn't as a state, then therefore the local districts cannot either. Now, Jake, I want to stick with you for just a second. Does that necessarily follow? Just because they could have done it, they haven't done it, does that mean that a local district cannot do it? Right? The state could have mandated segregation, but hasn't.
I don't know. I mean, it seemed to me like the court just didn't like what was going on and was looking for an easy way to get to that conclusion. I'm not sure that they couldn't have. I don't know. I'm not sure.
What do you think? What do you think the plaintiffs were asking for?
Them to say it was unconstitutional.
The segregation was unconstitutional, right?
Yeah.
And do you think they wanted to do that?
I think
the court. Did the court want to do that?
No.
No, they didn't. And in fact, you know, they say, we are not tempted by the siren who calls to us that the sometimes slow and tedious ways of democratic legislation is no longer respected in a progressive society. We're not going to get out in front on this. We have been encouraged to re-examine segregation because things are different in 1947 than they were in 1896 or 1927. But we're not going to do that. We're not, you know, this is a Court of Appeals case. It's not quite up to the Supreme Court. But they don't want to do it. They're being asked to do it by the plaintiffs. And so this raises sort of another point about litigation, which is that the court always has ways to answer the questions that it wants to answer, as opposed to the questions that you want it to answer. So the plaintiffs, you know, might have been pushing in one direction, and they were likely very pleased with this outcome, even if the reasoning didn't quite get what they wanted it to get. So this is a case where you have to understand the authority, the lines of authority. The court is saying that the local district does not have the discretion to do this. And just note that, remember in Roberts, when we were developing, and in Plessy, when we were developing our tools, we said discretion towards the local district justified the segregation, right? Let them handle their local problems. Note that the opposite is happening here, right? A lack of discretion is being given, a lack of autonomy is being given to the local district, and therefore the court is not deferring in the same way that they did in the Roberts case and in the Plessy case. So it's a very different approach here, although not going sort of all in on overturning Plessy. Sarah, as you're saying, they don't want to address Plessy. That's in fact going to be the theme of the day, that courts don't want to address Plessy or overturn Plessy. Before we do move to the Sweatt and the McLaurin cases, I want to focus in on the sort of brief concurrence in Mendez. So the concurrence kind of begins with this statement: the teacher of a class of both English and non-English speaking pupils is not the same facility to the English-speaking pupils that the same teacher would, that the same would be to a class made up entirely of English-speaking pupils. Okay, so it's saying that it actually does make a difference whether you have a class filled with English fluent speakers or a mixture of English fluency and lack of English fluency. What is the concurrence talking about here? What is that all about? Yeah, Rachel.
I think that he's saying that, you know, it will take time and it will take away from all students if a teacher's got some students who aren't understanding what's going on and then some students that are only speaking English. But he also goes on to say that, like, the people of Mexican ancestry have been in California for hundreds of years, and a lot of them speak English.
Do you think that Judge Denman would be okay with segregation based on ability to speak English?
Yes, probably. I think he would, but not on being a Mexican. He wouldn't like that.
Right. If there was a sort of European descended student who couldn't speak English, would they be put in the English only class?
No.
No, not in the way that Judge Denman is talking about in the concurrence. And so what's the difference, right? What's the difference between segregation based on Mexican heritage, which the judge agrees wouldn't be proper or isn't proper, and segregation based on English fluency?
One is going to affect the learning of the rest of the students. The other one wouldn't, just because someone's a different race won't really hurt the learning of anyone.
One matters and one doesn't matter to the education process. Okay, and so if it doesn't matter to the education process, Rachel, I'll stick with you for a second here. If it doesn't matter to the education process, then what's the point of the segregation?
It's just racism. There is no point.
That's what the judge is saying, right? So, like, if you're going to do this and you have a good reason for it, then let's do it. But it doesn't work here, right? There's not a perfect overlap. There are plenty of students of Mexican heritage who speak perfect English. So why are those students being segregated? That doesn't make any sense. Now, let's say, Rachel, that what happens is the school district comes back and reads this concurrence and says, this looks interesting. We can't do it based on Mexican heritage, but you know what we could do? We could have separate classes for native English speakers or fluent English speakers, and separate classes for students for whom they're not fluent in English. Okay, and then they do that, and what do you think that the likely makeup of the classes for non-fluent speakers would be? What do you think the demographics would be?
I think it would still look the same. They would probably see someone's color of their skin and put them all in the Spanish class, and then all white kids all in the English speaking class.
So maybe. So they could actually use, just use a stereotype and say, oh, your last name is, of Hispanic origin, and therefore you're going in this class. But they also could, let's just say that they do it properly, right? That they actually give an appropriate diagnostic that tests English fluency. Okay, so I'm going to assume good faith for a second. What still in the classes for non-fluent speakers, what do you think the demographics are going to be? It's the same answer you just gave.
It would still be the same answer I just gave that I forgot.
Right. It's going to be mostly because of the demographics of the district, right? They're not having a lot of like Slovenian heritage students in this district. The vast majority of students who do not speak English are going to be of Mexican heritage, and that's who's going to be in that class. There will, if it's administered in good faith, also be a fair number of students of Mexican heritage in the English-speaking class, but this other one will clearly be almost exclusively students of Mexican heritage. Would that be unconstitutional?
No.
Let's just take it from the concurrences standpoint. Would that be unconstitutional?
No,
Why not?
because you're separating based on learning again and the effectiveness of learning and not their actual skin color.
Okay, and the skin color would trigger what? That a learning distinction would not.
Skin color would trigger that this is just racism and not learning.
Well, make it a legal thing. Why might racism be illegal?
Because it's not separate and equal. It's not equal.
Yeah, Sarah's got it. It's an equal protection problem. Okay, so the problem, what race gets you that distinguishing based on ability to speak English doesn't get you is higher scrutiny, right? Under equal protection. When we see a race-based classification, our equal protection bells and our strict scrutiny bells should be binging really loud. But if we see, and the word that the concurrence uses that I want y'all to focus in on is differentiation, right? Whoops. I'm trying to type it in the chat and I'm typing somewhere else. Differentiation based on race is going to trigger strict scrutiny. Differentiation based on ability to speak English, not, okay? Even though maybe in some instances it ought to, because maybe it's just a proxy. And so what the concurrence is talking about here is really a problem with tailoring. They say that this policy is not tailored in any way to something that might be justifiable, which would be separating students based on native language or something like that. There might be national origin problems with that. We're going to encounter these kinds of cases later in the course, but I want you to keep in mind the idea of differentiation. It's actually explicitly not equal. So this is not just Rachel, but anybody. Let me try to phrase it effectively. The concurrence is saying that a classroom made up exclusively of English fluent speakers and a classroom made up of some English fluent and some not English fluent speakers would be different, okay? And he seems to be saying that it would be justified to have separate classrooms for those individuals, right? Fluent speakers and non-fluent speakers. Would that be equal? Would those students be separate and equal? Or would they be getting different things? Yeah, Lindsay. Where are you? There you are. Uh-oh.
I'm
Can y'all
sorry.
hear her?
Question
Okay.
really threw me off.
Say that again.
Can you hear me?
I can hear you now.
Okay. What was the question again? I'm sorry, my mute button threw me off.
Okay. The question is it equal when you have separate classrooms based on language fluency? So a classroom for English fluent and a classroom for not English fluent students.
The education wouldn't be equal because, like, presumably you would have more teachers or more resources at the school where they don't speak English to try and get them to the, like, same level of fluency as the other school.
Yeah. I mean, at the very, like, most basic point, they probably wouldn't exclusively speak English at the school, in the classroom for students who aren't fluent in English, right? That wouldn't be a terribly effective educational program to be speaking in a different language that most of the students are not fluent in. So it would explicitly not be equal. And so you know the answer is there in this word differentiation. It's different, right? So I'm introducing the concept here because as we get into different types of segregation based on language ability, segregation based on disability status, segregation based on interests or talent, right? For an academically advanced school, for example, it's differentiation. Is it unconstitutional, right? Is it an equal protection violation? I'm just introducing the concept. We'll have the discussion later in the class. Are there other questions on Mendez before we move into Sweatt and then McLaurin? Or final comments here on Mendez? We good? All right, so let's move forward into Sweatt and McLaurin. Just so you guys know who they are. Here is Mr. Sweatt on his first day of class at the University of Texas Law School. And here, a student actually gave me a copy, like an original, I don't know what it is, but it's a copy of this photograph that seems to have been like in the clip files of some newspaper. Their father-in-law, I think, had like bought a newspaper's archives, and this photo was in there, and they came across it and they gave it to me, which was cool. This was about I don't know, maybe 5 or 6 years ago. So this is Mr. McLaurin, and this is the situation in the classroom that he was attending at the University of Oklahoma Graduate School for Education. So Mr. Sweatt and Mr. McLaurin are our protagonists today. And really, before we talk about them, I want to talk about their cases. What is different, what is distinct about Sweatt and McLaurin, the cases, from Mendez or Ganglum or Roberts, the other school cases that we have encountered? What is sort of the primary, like, jumping out at you difference between those two situations? Yeah, David, I see your hand.
I mean, he's in the same school, he's in the same classroom, he's in the same buildings. He's just kind of off to the side.
So for McLaurin, he's already there.
Mm-hmm.
Okay, so there isn't a separation. So I'm going to come back to that point in a second. But what else? Even before you get to the circumstances that are being challenged, what else is distinct about Sweatt and McLaurin versus Ganglum, Roberts, Mendez? It's really basic. Yeah, Alex.
Just the fact that it's higher education.
Yeah, so why is that different?
Well, I know one of the men is in law school and then one's graduate school. Is that what you mean?
Okay. And what are they in Mendez and in Ganglum and in the Roberts case? What
Elementary.
What were those students?
Or
yeah, they're in K-12 schools. And so what's the big difference between a K-12 school and a graduate school? I mean, there's a lot of difference. Although y'all might feel like you're in middle school all over again as you're in law school. It's very different. What's the biggest difference? I see it popping up here in the chat. Hold on, I've lost the chat. Yeah. Level of school, higher education. Shelby?
Yeah, I was just going to say that it's not compulsory like elementary and high school is.
Right. I mean, y'all don't have to be in law school, but K through 12 people have to be in school. And so it's not compulsory. So I guess, Shelby, if I could stick with you for a second, does that make a difference from a legal standpoint? Should it make a difference from a legal standpoint? Should there be more ability to segregate in one or the other based on the fact that one is compulsory and the other is by choice?
I don't think so, just because like discrimination is discrimination, so you have to evaluate that the same no matter what. It might feel different because if you're being forced to do something, then you can make more arguments about like the state providing access to resources and things like that versus whether if it's voluntary, the state has the argument, well, you don't have to give you something if we're not imposing an obligation to attend in the first place.
Okay, so you may not have a right to schooling at the higher ed level, in part because you don't have to be there. What about this argument that we've seen in Plessy and in Roberts, and I guess in Ganglam a little bit, that this is just, segregation is really just about sorting. It's just about sorting people out. Is that more or less applicable in the higher ed context? Shelby, you can go, or anybody can jump in here.
Well, I mean, as far as the sorting context, if school is voluntary, you can choose wherever you want to go. You're not limited by the district that you're in. So it's not like the school district is saying you have to go to this particular school. If it's voluntary, you can go to any school in any state that you want. You're not really limited in that way.
Okay, good. Reggie?
I guess kind of taking the argument from Plessy, like if there is like a higher education, like say like if there is a law school, there should be an equivalent law school available based on race, like under like equal protection. So, like they have to have the same, like it should be equal in like every way at the surface level at least.
Could a state like Texas simply pay to send Mr. Sweat to law school in Wisconsin?
Probably not, since like each state should, I guess, like has a duty to kind of like provide another outlet for like its own citizens.
Could they send Mr. Pay could they say, look, we're providing equality because we're going to pay for Mr. Sweat to go to Harvard for law school. We won't allow him to go to the University of Texas, but we'll pay for him to go to Harvard. He won't have to pay a dime.
I guess it kind of depends on like how many other citizens like in Texas also have that same desire to go to law school.
So let's say they're going to send, they really want segregation, so they're going to send all of their black potential law students to Harvard. You don't want to say that they can do that.
I mean, something about that just doesn't sound right, or I'm not sure how to explain it honestly.
Okay. Yeah, Evan.
Can you hear me? Okay.
Yep.
Okay. I had trouble earlier. I was just going to say that, and something that came up, I feel like in the Sweat case, was that it kind of it would kind of then force those African-American students sent to Harvard or sent wherever, they would be losing the choice to practice in their home state, or the same benefits that white students at the University of Texas would enjoy, of all those intangible and tangible things that you get from being a part of a law school, like reputation and prestige and the interaction with faculty and alumni and those different things with the people that you're probably going to interact the most with in that field. It kind of removes them from that area. And so then they don't have those, as far as, still having, it forces them to choose to practice somewhere outside of the state, I guess.
Yeah. So, and Rose, I think you're making the same point here in the chat. It takes away the choice if you just send somebody away. In a weird kind of way, it is, it's clearly not equal, but the question is it going to be a valid constitutional strategy? Probably not. I think you guys are probably right about that. But Reggie, I'll come back to you. What might it do, right? So if Sweat showed up at the Texas Law School and said, hey, I want to come to law school, and they say, well, you can't come here, but you can go to Harvard. What might Sweatt do?
I mean, I guess like sue the law school, or I
Could
guess
sue the law school, but he's about to go to Harvard for free. So what else might he do?
I guess go to Harvard.
Let's say you showed up, or maybe I'll make it Evan. Evan, let's say you showed up to the University of Memphis, and Dean McClellan said, "Hey, actually, we are not going to admit you anymore. We're going to send you to Harvard for law school." Okay, what might you do? I see you giving a thumbs up.
Go to Harvard, probably.
You might go to Harvard, right? You might just not sue. You might say, well, I wonder why they're doing that to me. Why, even if you know why they're doing it, like Sweatt would know why this was happening. But Sweatt might say, look, if they're going to pay for me to go to Harvard, then I'm going to go to Harvard and let them pay for it. And I'm not going to sue them, right? So it might not be a constitutional gambit that is being done here, but it might be a very good strategy from the Texas Law School's standpoint to foreclose this very lawsuit, right? Instead, of course, what they do is build a separate law school for African American students in Texas, and that's the case that we get. But the reason I mention this is because you guys may have heard of Ben Hooks or Russell Sugarman or A.W. Willis, famous African-American lawyers in Memphis history who were denied the ability to go to state law schools in Tennessee, but had their law schools paid for by the state of Tennessee at other places. And then used their legal degrees to come back to Memphis and challenge segregation. So, in a weird kind of way, Tennessee funded, at least in the Memphis context, the legal education of many of the lawyers who led the fight against Tennessee's segregation. So just like, that's what happened. None of those people challenged segregation in law schools of Tennessee. They just took their free education and then came back and then challenged it. So that's the story. So now let's talk about the cases. So Evan, I want to stick with you for just a second. What is all this stuff that they're talking about? Reputation and prestige and opportunity to practice. If you had to boil that down into a tool that the court is using here, what would you call that? Why are they talking about all that?
I'm not sure if this is what you're looking for, but I was just thinking about like the sort of things that you get from I think the court said something like that those were like qualities that the school had that were incapable of objective measure or something like that.
Right.
But which
So
make for a great law school. Like they were trying to describe what makes a great law school, and I guess implicitly versus what would not make a great law school, and sort of getting at the idea that if you were given a choice between that law school and this new one that they were creating, that someone it wouldn't even be a question as to which one you would choose. Maybe that's not what
Okay.
you were getting at, but
It sort of is. So what do you think? In Mendez, we said that the plaintiffs were asking for what? They didn't get it, but what were they asking for?
the plaintiffs were asking for, they wanted them to rule that, take a look, I guess, at Plessy and rule on kind of dismantling separate but equal.
Right. So they're saying, hey, we need to overturn Plessy. They said it in Mendez, and they say it in this case. we need to overturn Plessy. Separate but equal is not constitutional. And so, Evan, you're describing all this stuff, and you're sort of hitting on that last point, which is if you had the choice between this school, the University of Texas Law School, and this new school, the University of Texas Law School for African American students, you wouldn't consider the question close. What does that suggest about those two options?
They're not equal.
They're not equal. And so what does that do for the court? What if they're not equal, what does that allow the court to do?
Sort of address the separate but equal, but distinguish it from cases where they're distinguishing it because there was a Texas law school, there was not one for African American students, which is different from some of the previous cases in K-12 where there was technically schools provided under state statute, and whereas here there just wasn't. And so I feel like I'm kind of rambling now, but
yeah, I don't know. I mean, I feel like what we're trying to figure out is, I think you've gotten us pretty close here, that the court is asserting that these schools are unequal. And so my question, I see your hand, Lindsay. My question is, what does that allow the court to do? I'll just leave it at that. What does that, if they're unequal, what does it allow the court to do with with regard to Plessy?
No?
Yes.
Okay, perfect. It's off today. I don't know why. Sorry about that. But when we were talking about Mendez, we were talking about the fact that the court wanted to say that it was all unconstitutional, but maybe took a step back. I think that's what you're getting at here is with Sweatt, they wanted to do the same thing, but instead of going as far as to just say it's all unconstitutional, they found these narrower grounds where they're building up the fact that they're super unequal so that they can say it's bad under Plessy instead of having to say get rid of Plessy.
Exactly. So they're able to use Plessy against itself, which you guys identified as a potential strategy here, and say, look, it's not equal. Plessy says it has to be equal if it's going to be constitutional. It's not equal. Okay. And I think that in Sweatt, that's pretty easy. But David, are you still around? I can't find, there you are. You said you wanted to talk about McLaurin. Now, McLaurin is going to the same school.
Mm-hmm.
How is his experience not equal?
I mean, he basically, he's isolated. Like he's in the same space, but he's he's basically got a bubble around him, and that bubble prevents any of it's almost like being on Zoom, that we're in the same space, kind of like we're sharing, but like everything else, during class, like we're doing that, but everything else, we're kind of doing on our own, and we have no way to even interact with anybody.
Okay. So does the court overturn Plessy versus Ferguson in the McLaurin case?
No, I mean, they basically just say that, look, he's already here. You might as well just let this happen, because the equality, they're saying that while he is separate and they've made an attempt to make it equal, it's not actually equal, because in higher education and you need those opportunities for interaction and side conversation and developing ideas further, and he doesn't have those opportunities because he's so isolated.
Do you agree that this is sufficiently unequal to allow the court to sidestep, as Chelsea has said, Plessy? The glaring problem, or the glaring question is, should we re-examine Plessy? Is it so unequal here that the court legitimately does that? Or do they just not want to do Plessy yet?
I mean, I think that, this is like, they're kind of, because it's different enough that they're able to distinguish it, but I don't know. It's it's all. I mean, you're still turning him into a pariah. And when you've done that, it's inherently not equal.
Okay. Others? Is it sufficiently unequal that Plessy can handle this case? We don't have to overturn Plessy in the McLaurin case. He's getting the same degree. He's learning from the same teachers. He's going to the same school. He has the same library. Everything is the same. What do y'all think? Anybody else think? Anybody want to say, nope, it's equal. They should have done it here. Yeah, Abby, you don't have to say that.
I don't know how to phrase it, but I feel like a reason why in McLaurin where he has all the same resources, but then he has to sit at all the different tables, as compared to Plessy. So with Plessy, we talked about how it's obvious that the intent of it was different than what they were saying, right?
Mm-hmm.
Because obviously they were doing it to discriminate, but they weren't saying that they were doing it to discriminate. But here, well, I guess it's kind of the same, because there's no other reason for it, right? You have all of the same things, but then you make them sit at a different table. There's no reason at all. So actually, I guess it's the same. I don't know. I guess to me, I don't know how to put it into words. I'm sorry.
I love how you put it. There's no other reason. There's no reason for this. There's only one reason for this, right? And it's the court actually is kind of gentle with the University of Oklahoma. They say, we think that the only reason they're doing this is because the Constitution of Oklahoma requires them to do it. Not so much that the university itself is wanting to do this, but that they are bound by the law as it exists. And therefore they have to do this in order to comply. They're almost saying, we wouldn't do it if we didn't have to, but we have to. And so, and so we do. But of course, that begs the question: why does the state require it? And it's what we're seeing in McLaurin is some, without overturning Plessy, an acknowledgement of the perspective that is offered by Justice Harlan in his Plessy dissent, which is that we know the rationale here, and it's racism, and that's discrimination, and that can't be a justification for separation, right? This isn't just administrative sorting. This is an intent to make this person a pariah, as David has said. But though they might be there, by the McLaurin case, the court is there, they still don't overturn Plessy, right? And so instead they give this sort of, they use the same basic trick that they used in Sweat. Sweat and McLaurin came out on the same day, right? So they're companion cases. And they use the same basic trick. And the tool that they're using is expanding the concept of what has to be equal, okay? What has to be equal isn't just the number of books available to the students. It's not just the curriculum that is available to the students. It's also these intangible things. And in Sweat, reputation, prestige, ability to learn with people that you're going to practice with as part of the bar, but it's also the experience itself. And that's what they're talking about in McLaurin, that the experience itself is impacted by this segregation. And so as we turn to Brown, I want to note two things in the McLaurin opinion, and they're sort of in the last column. One is that the state imposed nature of the pariahship is the problem. Okay, so sort of toward maybe the third to last paragraph, the last sentence is state imposed restrictions which produce such inequalities cannot be sustained. And then the paragraph that I want y'all to think really hard about is the next one. It may be argued that appellant will be in no better position when these restrictions are removed, for he may still be set apart by his fellow students. So they're imagining a future in which McLaurin has won this case and goes back to school, and though he doesn't have to sit in that row by himself, he goes to the lunchroom and nobody sits with him. Or he sits in a row and nobody sits in that row. Or he goes to the library and nobody sits at his table, or people leave the table when he gets there. The court says there's a vast difference, a constitutional difference between restrictions imposed by the state, which prohibit the intellectual commingling of students, and the refusal of individuals to commingle where the state presents no such bar. Okay? And what this is setting up is a distinction between a prohibition on people getting together and a mandate that people get together. Okay, and so we're going to come back to this idea as we push forward in and through Brown. So we'll pick up with all that on next week. I hope you guys have a good weekend. If you got questions, I can stick around for a few minutes. Or you're just all going to leave. I don't blame you.
Professor, I was reading that, but I had so you suggested about looking at Harlan one. So I pulled the book on Vinson as well, and was seeing that
You pulled a book on what?
On Chief Justice Vinson.
Okay.
And they were saying though that in conference that the McLaurin one, everybody came to this decision really quickly, but in Painter, only 7 justices were on board right away, and that it was a sort of a longer pull to get them to come around on that. So, which I thought, I mean, again, talking about the difficulty of as we look at these and deciding them, that in my mind, the Painter one is easier, to justify and show the separate and ensuring that it's not equal. But I think, but it's interesting that McLaurin was really easy for the courts.
Was the easiest case.
Yeah, of that.
Yeah.
And that's why it's such a short, succinct, opinion.
Yeah, and you can tell after these 2 cases, the writing is on the wall. It's just a matter of translating these principles to the K-12 context, which takes time, but it's hard to know how, after McLaurin in particular, that segregated K-12 schools could last. The only distinction is the mandatory nature of it, right? So that they really do still have the sorting argument that is absent in McLaurin. I mean, the photo is just so striking, it's just so ridiculous that it's kind of on its face obvious.
He's sitting, he's like the bad kid in class, they have to sit by themselves.
Right, right.
Yeah, so.
Cool. What book did you pull on Vinson?
Chief Justice Fred M. Vinson of Kentucky, by St. Clair. And
great title.
Yeah, right. Very creative. I don't know where these guys are from, but I was just down at the library and grabbed a few books. So,
okay.
Yeah, cool.
All right. Have a good weekend.
I'll see ya.
See ya.